Good afternoon, everyone. Thanks, Emma and Knox LMC, for having me here today in your practice briefing. It's really nice to be here. Just to introduce myself, I'm hoping that everyone can see the slides that I'm sharing. If not, please sort of wave your hands or pop it in the chat box and we'll try and sort that out. So to introduce myself, my name's Pooja Solanki. I'm a legal director in the primary care team at Capsticks. So for today's seminar, what I'm going to be looking at is really about getting your house in order in terms of your medical business and also your property. So it's really to ensure that your medical business and property are properly protected, but not just that, but also properly documented. So I'm going to look at partnership deeds first, then move on to declarations of trust, which you may or may not have heard of, and then finally just touching on GP property ownership and occupation. So the talk's around 30 minutes long, so we'll have plenty of time at the end for questions or any discussions that you might want to have. If you have any questions along the way, please just do raise your hand or pop it in the chat box. This is really informal, so I'm happy to take them at the end when we can pick them up at the end. So just a bit of background about Capsticks Solicitors, just in case you haven't heard of us. Capsticks are a specialist healthcare firm. We have a dedicated GP team, so that's a primary care team, and we provide specialist legal advice, not just to GPs, but also dentists, other healthcare professionals, and it's across the board. So we provide advice on corporate, commercial, real estate, regulatory, and as well as employment. So before I kick things off, I like to provide just a bit of background information, and it's really nice just to set the scene, I think, of where we are in primary care before we kind of go back to basics on partnership. As I'm sure you're all aware, I think it's been very much the focus. It's been very clear that the focus of primary care has been very much about working at scale and collaborative working, and we've seen this through a number of avenues in the last sort of 5 to 10 years. Firstly, the formation of PCNs a few years ago. We personally have seen a huge increase in the number of M&As, so mergers and acquisitions of GP practices post-COVID. And I do still very much think that's the direction of travel for primary care. And whilst that's the case, I think it's really important to bear in mind that in order to achieve efficient working at scale and efficient collaborative working, you need to have your house in order. So you need to make sure that you've got correct, valid and up-to-date documentation in place, not just for your medical business, but also for your property. So in terms of figures that I've looked at since probably, I'd say June 2022, so last summer, I believe there are around 7,000 GP practices in England and Wales, and I would estimate around 85 to 90% of them will be practicing as a general partnership under the Partnership Act 1890. So that remaining 10 to 15% is probably going to be made up of individual practitioners, the sole practitioners, a handful of practices that have maybe incorporated and operate as a limited company, and probably a few that have left over that may have been taken over by trusts, for example. So you can see from those figures that the majority of GP practices will still be practicing under the Partnership Act 1890. And I've given you a really boring definition from the Act. It's really simple, it's really small, but a general partnership is essentially the relation which subsists between persons carrying on a business in common with a view of profit. And what that's broken down to is 2 or more people who come together with a business idea in common with a view to making money. And that's how you are operating your medical business. So moving on now to why you need a partnership deed. So you can tell from when that act was put in place, which is from 1890, what I will say is that it has never been updated since then. It's never been amended, and it's incredibly archaic. So why do you need a partnership deed? There's 3 reasons. The first, I think, is fairly obvious, which is it irregularises the partnership by providing written evidence of the agreement between the partners. And I like to call your partnership deed really your written Bible. it will cover all of the issues that you need in order to make sure that you can run your business. So from taking accounts, decision making, how much leave you can take, what leave provisions you can take, what happens if a partner retires or dies. So it's really providing that certainty to all of the partners and clarifying their rights and obligations on their medical business. The second bullet point is probably the most important bullet point as to why you need a partnership deed. And if there's anything that we take away from today's seminar, it's this. It avoids being a partnership at will. You've probably heard that terminology before. So to explain it a bit further, if you don't have a written partnership deed in place, you will automatically be governed by the Partnership Act 1890. And any partnership that's governed by the Act is called a partnership at will. And trust me when I say it's not something that you want to be. Like I said, the Act is archaic. It's very short. It doesn't have a lot of provisions in it, and it certainly doesn't have provisions in it that you need in order to govern your modern medical business. So I'm going to stop there on partnership at will, because the next slide actually goes into a little bit more detail about what a partnership at will is missing. And then finally, it avoids disputes. So I'm obviously not saying that if you've got a written deed in place, you're never going to have a dispute or disagreement with your partners. The point is that you will have a written document that you can fall back on that will hopefully have mediation provisions. So internal dispute resolution procedures whereby you may be able to resolve that dispute with your partners, or alternatively arbitration provisions where if they can't be resolved internally, they can be taken externally, say for example to the LMC, who might be a third party who can help you resolve that dispute. And your deed will clearly set out the procedure by which you can try and resolve, to try and basically avoid going to court. And I've put there a really interesting case called Chima and Jones. The reason why it's so interesting in this particular forum is that Chima and Jones were GPs. And Chima and Jones is the latest piece of case law in our country that governs partnerships. So just to talk through this case, I'm not trying to scare you because I appreciate this is quite a rare situation, but we see it a lot in terms of GP disputes and issues. Chima and Jones were GPs, and they were a two-partner partnership with a deed in place that was valid. And as is the case with all two-partner partnerships, all decisions, including the decision to dissolve, were unanimous. So they admitted 3 new partners, and let's say they started on the 1st of July. Those 3 new partners did not sign up to the partnership deed. So as of the 1st of July, they joined. Chima and Jones then had a huge falling out, to the point where Jones and the 3 new partners served an injunction on Chima to prevent him from entering the practice, from seeing patients, from seeing staff, and also served on him a notice of dissolution to effectively remove him from the partnership and carry on with just the 4 of them. Chima counter-argued this notice of dissolution by saying that under the terms of the partnership deed between him and Jones, any decision to dissolve was a unanimous decision, and because he didn't agree to it, it wasn't valid. The case went all the way to the High Court, and the courts actually ruled in favour of Jones and the 3 new partners, on the basis that when the 3 new partners joined, they didn't sign up to the partnership deed between Chima and Jones, and therefore that partnership deed automatically became invalidated, and Chima could not rely on the terms. And one of the key disadvantages, I would say, of a partnership at will is that any partner can dissolve the partnership at any time without notice, which is essentially what Jones and the 3 new partners did. So being a partnership at will is incredibly precarious, especially if you've got a disgruntled partner who might want to cause a dispute or might want to cause trouble, and it can put your, not just your partnership, but obviously your NHS contract at risk. So these are some of the other clauses that are missing in a partnership at will. And remember, a partnership at will is what's governed under the 1890 Act. So in your deed, or as you may be governed by your medical business, your profit share will be equivalent to sessional commitment. That's not what is said in a partnership at will. All profit shares and therefore losses are equal, irrelevant of your sessional commitment. Like I said, that act is very old. It doesn't really have any provisions about leave entitlement, so things like maternity, paternity, parental leave, adoption, etc. Under a partnership at will, you can't actually retire or expel or suspend a partner. So in terms of a partner leaving, what would actually happen is that if they left or if they were expelled, it's called a technical dissolution, and you dissolve back and then you have to reform. There are no probation period provisions. Now, I know we don't really see probation periods anymore. I certainly see them a lot less than I did sort of 10 years ago. But if you did want to bring in a new partner, that wouldn't be accounted for under the Act. There are no provisions relating to decision making and no provisions relating to dispute resolution. Caps lock dissolution again, because like I said before, one of the key things about a partnership at will is that any partner can dissolve at any time without notice. So what are the consequences of dissolution? So in terms of what would happen is that your GP practice business would have to be wound up. That's called a technical dissolution. All of the partnership assets would have to be sold. Your NHS contract, and this is whether you're GMS or PMS, it doesn't matter, would automatically terminate. The ICB and NHS England would take that contract back, and it would then be in their hands as to decide what to do. They may either disperse the list or they may put it out to tender. One of the big effects of dissolution is going to be your premises. So I do obviously touch upon premises a lot later on, but in terms of dissolution, you're either going to own the premises, so whether that's freehold or long leasehold, or you're going to occupy them. Either way, you will receive, by virtue of your NHS contract, notional rent if you own, or rent reimbursement if you occupy. Now, if your NHS contract is terminated, so is your right to receive notional rent or rent reimbursement. So on dissolution, you could potentially be left with either a mortgage liability if you own that you can't fund because your notional rent has ceased, or a lease liability where there would be rent payments, service charge payments. So again, you can't fund because your rent reimbursement has ceased. And then finally, redundancy of staff. So if you don't have a business, you don't need staff. So all of the staff would have to be made redundant. Now, one of the core founding principles of a partnership is that partners are jointly and severally liable to each other. And what I mean by that is that losses of the partnership are shared between the partners by putting their hands in their pockets. So any redundancy payments that may be due to staff, depending of course on how it's calculated according to how long they've been at the practice, would come out of the partners' pockets, as would all of the other costs of dissolution. Now moving on to partnership changes, I'm asked by clients quite a lot as to when they should update their deed. Before I go on to actual partnership changes, so whether a partner retires or a new partner joins, I think it's a really good idea as a rule of thumb, look at your partnership deed every 2 to 3 years. Things change very quickly in GP practices. You may have provisions relating to decision making, leave that's changed. So it's really good to just take that deed out of your drawer, dust it off, read through it and make sure it's still current. Make sure you're still happy with it. Does anything need updating? If there have been no partnership changes and you want to amend your deed, all you simply need to do is have a partnership meeting with all of the partners, agree the amendments, list them out in your meeting as minutes, everyone signs it and append it to the partnership deed. And that will count as a valid variation to your partnership deed if you're simply just changing some of the terms. In respect to partnership changes, let's take retirement of a partner first. So if a partner were to retire or die and they need to be removed from the partnership deed, if you have a valid deed in place, you do not legally need to update your partnership deed. This is because a partnership deed will have provisions in it that allow for the retirement or death of a partner, but to then still be legally binding on the continuing partners without having to remove their name. Your deed should also include all retirement provisions, and I go into this in a little bit more detail in the next slide. So I'll park that point there. The partnership change that you really need to be aware of, and I go back to what happened in Chima and Jones here, is if a new partner joins. If a new partner is joining, let's say on the 1st of August, you must update your partnership deed prior to or on the date that that new partner joins. And if you don't, on that date, so 1st of August, you will automatically become a partnership at will. The terms of any previous deed will fall away, and you will straight away be governed by the Partnership Act 1890. And this is even the case if that partner joins on a probationary period. They need to be updated from day one of that period. I've mentioned Chima and Jones again because that's exactly what happened. Just as another consideration for when that new partner joins, and think about the premises. So you might want to include in the partnership deed, if you own the property, whether that new partner has an obligation or a right to purchase a share of the freehold, or alternatively, if you occupy, that they need to be bound into the terms of the lease. As you may well be aware, and I go into this in a bit more further detail later, only 4 names can be on the legal title, and that's whether it's a lease or a freehold. So if that new partner is coming in and they're number 5 or afterwards, make sure they're bound into the terms of the lease under the deed. So just touching upon outgoing partners, these are the provisions that I would want to see in your partnership deed to make sure that you don't, for example, need a deed of retirement when a partner leaves. So, for example, the first, leaving accounts or annual accounts. When a partner leaves, you need to undertake accounts. Do you want to have that to happen on the date of retirement or death, or do you simply just wait until the next annual account date and then pro-rata it up until that date? Paying them out, so payment of their capital and current accounts, within what time period would you want to pay them? 6 months, 12 months or longer? Would interest be payable? If interest is payable, is it payable from the date that they leave or the date that they should have been paid punitively, and then interest occurs thereafter? If you own the freehold or long leasehold and it has a capital value, think about the valuation. How are the premises being valued? There needs to be an obligation of the transfer of any partnership property and assets back to the continuing partner. Think about third parties. So there will be a number of third parties that you need to notify. So, for example, NHS England, to remove them from the NHS contract, removal of their name from the CQC registration. Obviously, your accountant will assist in removing them from any HMRC documentation, the partnership bank account. Please check your deed for post-retirement restrictions. Not all partnership deeds have them, but some do. Ours contain them if the client wants to have them. So there might be a restrictive covenant. So, for example, the outgoing partner might be prohibited from working or acting as a GP, a partner, a locum, etc., within a certain radius of the premises for 6 months or a year. Make sure you double check it because you don't want to be in breach of it. Even if your deed does have that restriction, you can obviously agree with the continuing partners to try and disapply it if they're happy to do so. Moving on to provisions that I think you should also be including in your deed. There are a number of provisions that you should be including in your deed that are tailored to GPs. This is just one example that I do find some deeds and many deeds don't include, and that's relating to your primary care network. So within your network, you will have a separate network agreement that you and the practices in your network will have signed up to, and that's fine. In relation to your partnership deed, there are specific provisions that you should be including. The first is compliance with that network agreement. Now, your network agreement will probably only have one authorised signatory, and that will be one partner within your partnership who signed it on behalf of the partnership. You then need a corresponding obligation in your deed that, firstly, all of the partners have agreed to that network agreement, and secondly, that they will all agree to comply with the terms. I also like to include what's called a PCN partner, and that PCN partner is a nominated partner within the partnership who may attend network meetings, who may take back to the network any decisions that the partnership has agreed as a whole, And so there needs to be some kind of obligations on that PCN partner to obviously not act outside of those rights, and those rights should be recorded within the deed. So those are general provisions relating to the PCN. You also need to deal with the monies that are coming in from your network into the partnership. So firstly, it's the general treatment really of any surplus or deficit monies, which might be the case, that come from the PCN into the partnership accounts. And then you need to specify the flow down of that money into each partner's current account balance. And this is really important for your accountant when they're calculating payments that may be due to an outgoing partner on retirement or death. Finally, we see a lot of PCN incorporations. So that would be forming a company that then becomes a part of your network and becomes really what's called an associate member of the network. Partners within the partnership may hold shares in that PCN company. So you need to make sure that the shares that are held by one or more of the partners in that company are then included in the partnership deed as an asset of the partnership. And we would refer to that in our deed as a share asset. So to conclude on partnership deeds, I think it's really helpful to ask yourself these questions. First of all, and it might be obvious, but do you have a partnership deed in play? If so, is it valid? Have you had a new partner join recently or in the last few years that for whatever reason, one reason or another, has not been properly bound into the deed and signed up to the deed? If so, what is the risk? And your risk is that you've reverted to being a partnership at will, governed by the Act, and that any partner can dissolve the partnership at any time without notice. And it's that you really need to try and rectify. And then finally, if you have got a valid partnership deed in place, is it tailored to your requirements, not just your personal business requirements, but to GP requirements? So including those PCN company provisions, including provisions regarding superannuation, things like that. Have a look through, make sure it is tailored to how you govern your business. So moving now on to GP property ownership and occupation, as well as declarations of trust. Before I go on to how you might occupy or own your premises, again, I like to do just a quick overview of ownership. This is quite legal, but I'm sure you've all heard of it. And it's really about the difference between the legal title and the beneficial title of your property. This can sometimes cause confusion, especially when we look at legal titles and there's retired partners' names on there that retired sort of 5-10 years ago. So the legal title is the names of the partners who are held at the land registry. There can be a minimum of 2 and a maximum of 4 names that can be on the legal title at the land registry. The equitable interests are sometimes also called the beneficial ownership, can be unlimited. And what that means is there can be unlimited people or partners who actually own the property. So in the example that I've given, we've got 5 owning doctors. The legal title is held by doctors A, B, C, and D. Upon trust for the partners who own the equitable title. And in this example, it would be A, B, C, D, and E. E being the 5th partner who doesn't have legal ownership, but has equitable ownership and has exactly the same rights as whoever owns the legal title. In terms of how GP properties are held, again, this is quite technical and legal, but I think it's helpful just to have it clear in your mind. There are 2 ways that properties can be held. It's either as joint tenants or tenants in common, and you may have heard of this terminology. The difference is that joint tenants are where both partners will jointly own the whole property. And upon the death of either one of the co-owners, their share automatically transfers to the other co-owner. With tenants in common, it's completely different. Each owner in a tenants in common property will have a specified share, and they can do whatever they want with that share. So on death, they can specify whether under the terms of the deed, declaration of trust, their will, what would happen and who it transfers to. GP properties are almost always held by the partners as tenants in common. I think I've only ever seen it held as joint tenants once, and they were husband and wife. And obviously, in terms of inheritance and tax, they wanted it to go to each other. So in the example that I provided before, it would simply say that A, B, C, and D hold the property for A, B, C, D, and E on a trust for sale as tenants in common in either equal shares or unequal shares. It doesn't matter, it's how you've bought in and at what percentage. The point being is that that share ratio needs to be recorded somewhere, whether it's in your deed or whether it's in your declaration of trust. So moving now on to ownership of property. So before I go on to these different bullet points of how you can own, just to clarify, this is owning a GP property which has a capital value. So that could be a freehold or a long leasehold. And I think this can be split into 3 separate categories. So the first is where the property is owned by all of the partners, and those are the partners in the medical business. Therefore, at this situation, owner and occupier status is exactly the same. The people who own the medical business are exactly the same as the people who own the property. The second bullet point is where the property is owned by some of the partners as well as retired partners. And by retired partners, I mean a partner who is retired from the medical business, been removed from the NHS contract, paid out for their share in the business, but decided to retain their share in the property. And at the point of retirement, the owner-occupier status is no longer the same, because that retired partner essentially becomes akin to a third-party landlord. Then the final scenario is where the property is owned by some of the partners, but the partnership also has non-property owning partners in the partnership. And that could be for any reason. It could be for a short period of time, or it could be for the foreseeable future. Where some GP practices, they're more than happy to admit partners, but that partner does not necessarily have to buy into the freehold or long leasehold. And in a very similar situation as to the second bullet point, owner and occupier status is not the same. So each of these 3 scenarios, I'm just going to go through what documents you need to think about having in place to make sure all parties, with whatever hats you've got on, landlord, tenant, retired partner, current partner, to make sure everyone's protected. So for the first bullet point, it's the simplest one. The medical partners own the freehold and own the business. So you should have a partnership deed in place, but also a declaration of trust. I'm going to go into declaration of trust in a bit more detail later on. The second bullet point is where things start to get a little bit more complicated. So the medical partners need to have a partnership deed in place. The owners of the property need to have a declaration of trust in place. But you also need to think about putting a lease in place. And that lease will be granted from the freehold owners, whoever they might be and whoever they might include, down to the partnership to ensure that the partnership as the tenant is properly protected. And then in the final scenario, it's very similar to the second. The medical partners will have a deed in place. The property owners should have a declaration of trust in place. And if it's the case that the non-property owning partners will not be buying into the freehold, there needs to be a lease from the freeholders down to the partnership in order to ensure that the partnership as the tenant is also protected and its occupation is also protected. So now moving on to, we've looked at ownership of property, where property holds capital value. This is now looking at occupation of a property where none of the partners own, retired or otherwise, and instead the partnership occupies and ownership lies with a third party. So that could be a 3PD like Assura, or it could be NHSPS or CHP, or it could just be a completely private landlord. And in that situation, there are 3 potential bases of occupation. So the first is a lease. And in our advice, or in our situation, we would always advise that a formal lease is in place. So be aware that this lease would be granted from the third party down to the partnership. It's a rack rent lease. And by that, I mean that it does not have a capital value. So just for the purposes of your accounts, your partnership accountants would probably show that as a liability on your accounts, not an asset. and each partner would hold a share of that lease in accordance with their profit share. So on that basis, the losses would also be shared in accordance with profit share. So for example, any rent payment, service charge, that would be paid in accordance with how much your profit share is. In the absence of a lease, the partnership could potentially occupy under a license. Now, we very rarely see licenses in place. I think the only really advisable situation to have a license in place is where you may be relocating. So if you're relocating and you're moving into different premises, you may want to govern your occupation of your current site, not by a lease, but potentially by a license if it's going to be short term. Licenses aren't ideal, not really from a landlord perspective or a tenant perspective, and actually thinking about it potentially could put your rent reimbursement at risk. And then finally, if there is no documentation in place, it will be undocumented. So there would be a huge ambiguity actually to how you occupy and the basis upon which you occupy, and also in terms of who's responsible for repairs, who's responsible for maintenance, alterations, etc. If you were to have a dispute with your landlord, it would be really difficult to try and resolve because there's nothing in writing. In that situation, you could probably argue that there's a business tenancy or implied license in place. So your actual occupation will be protected. It's not like that they can just kick you out. But the point is there's nothing in writing as to who is responsible for what. So our best practice advice, like I said, is to agree a lease. I've listed out the reasons why, and I think they're fairly self-explanatory. First is provide certainty, not just for the freehold owners, whoever they might be, but also for the occupiers. You as the partnership tenant, your occupation in that site is going to be protected. It's also highly likely that a lease is going to be required, if not insisted upon, by any mortgage lender. That's really an issue for the freehold owner, obviously, as opposed to the partnership tenant, but also required by NHS England. So it will ensure that you're not putting any rent reimbursement that you receive via your NHS contract at risk. It will minimise the risk of any costly litigation, like I just said. If you've got something in writing and there's a dispute as to who's responsible for what repairs and what alterations, you've got something to fall back on as to what was agreed. And the final reason, again, this is more for the owner, but it protects their investment by making sure that a written lease is in place. And how do you agree a lease? We always advise that you should engage specialist medical surveyors in drafting and also helping you agree the heads of terms. So the surveyor needs to have expertise in primary care and obviously the rent reimbursement system. We work with a number of medical surveyors who would assist with this process. Another reason for engaging a medical surveyor is that whatever lease you agree, and with whichever landlord you have, it doesn't matter if they're private or HSPS or CHP, that lease and its terms must have ICB approval. So once you've agreed that lease with your landlord, that then goes off to the ICB for them to approve. And if it's the case that a specialist medical surveyor and a specialist medical lawyer has helped you draft it, they will know what terms will be agreed and what terms might be rejected by the ICB. So it's really important to get that specialist medical advice right at the beginning. And finally, you would need to obtain a mortgage lender's consent. This is not for you to worry about, that's for the freehold owner to worry about. But just bear in mind that that may have an impact on timescales in agreeing the lease. Declarations of trust. I've used this terminology quite a lot throughout the seminar, and you may be wondering, what are they? Do we actually need them? And we get asked this all of the time. And my answer is yes. You do need a separate declaration of trust to govern your property as well as having a partnership deed. And the reason being is that if you've chosen to regulate your medical business with a deed, what the declaration of trust will do is regulate your property. And within that document, you will have a number of provisions. So firstly, going back to when I explained tenants in commons shares, it would be recorded in your declaration of trust. How income is shared, how expenses are split, what would happen if a partner were to retire or die, would their share be bought by the remaining property owners, would it potentially be offered to other non-property owning partners in the partnership, within what time that retired partner would be paid for their share in their property, interest payments. That would all be regulated in the declaration of trust. And this all goes back to the reason of, if a new partner joins your partnership and they're not bound into the partnership deed for whatever reason, and we see it happen a lot, the terms of your partnership deed, including all your property provisions, will become invalidated. So if a partner were then to retire, any protection that they may have had about payment to them for their core capital asset would have fallen away. If it's all recorded in a separate declaration of trust, the parties to that declaration of trust are still protected, and the terms of that declaration of trust are still binding. So that retired partner can still claim under the terms of the declaration of trust for payment for their share in the property. And it's really about ensuring that you're protecting your capital asset, bearing in mind, of course, that GPs can't trade in goodwill. So just to conclude on the property side, ascertain what the ownership or occupation of the property is. Do you still have retired partners who potentially still own a share in the property and will continue to do so? If so, think about whether or not a lease needs to be granted. If you have non-property owning partners in the partnership and they're not intending to buy in, think about whether a lease needs to be granted in that situation. Maybe check your title at land registry. Is it up to date? There may still be retired partners on it. It's perfectly normal. We see it all the time. And obviously that will correspond to whoever's on the mortgage as well. And think about whether or not that needs to be updated. And then finally, just to conclude on the documentation that you should be having in place, and I like to call it the triangle of documents. At the top, you've got your partnership deeds, and that will govern your medical business. And the offshoots of that are to ensure that your property is protected. So the declaration of trust, which will govern your freehold or long leasehold, and then think about whether a lease needs to be put in place. Thank you very much. Shall we move to the questions, Emma?
Yeah, thank you for that, Bridget. It was really interesting and some really good tips and things for partners and practices to look at. So thank you for that. We've not had any questions in the chat, but if anybody has got any questions, please feel free to raise your hands, pop in the chat. Greg.
Thanks a lot for that. I've been a GP partner now for nearly 34 years, and I've been through everything from joining a partnership without a partnership deed to getting a deed sorted out, getting the property sorted out, being an owner occupier, seeing partners come and go. And I think I know what's going on, and yet I listen very keenly. And the next thing I'm going to do when my practice manager returns tomorrow is go and check all this. It is hugely important for partners to be absolutely sure what their partnership deed says, how it provides for retirement, profit shares, buy-in, buyouts, incoming people, outgoing people, and I cannot emphasize too much to anyone else on this chat this lunchtime how absolutely crucial this is to get it right. And go back and make sure you've got it right. And then when you've done it now, make sure it's still correct this time next year. And it is hugely important. I do actually have a question, though, as well. I'm actually the owner-occupier of this building, and I am going to retire at some stage in the near future. And I would like to dispose of the assets. And if that works, fine, that's great. But in terms of people not being able to sell their property, there is an issue around being an external owner and no longer working. I mean, a separate lease arrangement back to the partnership, but there's also things like capital gains tax to worry about, disposing of an asset. Can I ask, what's the current arrangement with HMRC in terms of how long can you take to dispose of it before the capital gains goes up? I know there is a period in which you pay less and then a period in which you pay more, and I can't remember when it is.
So I would have to defer you to the accountants on this, but my knowledge on it is I believe it's 3 years, Greg.
3 years.
So I think it used to be called Entrepreneurs Relief, but it's called something different now. I think it's called Business Asset Disposal Relief or something like that. And that is a consideration for retired partners when they decide whether or not to hold on to their share, because they lose that relief if they hold on to their share in the property, I believe, for more than 3 years. But please do everyone check that with your accountant. Please don't quote me on that.
Yeah, thank you very much. I'll go and check that. I mean, it's not particularly absolutely crucial to sell at the point of retiring, but it is something I want to get sorted out, I've got to say. Thank you for that.
Thank you. Are there any other questions at all? Oh, Greg?
Yes, I've thought of something else actually. So when you've got a partnership agreement, does it actually just need to be signed by the partner, or should it be deposited anywhere, or should it be witnessed by a solicitor, or does it actually not matter provided you've got the documentation drawn up and signed by all partners?
So with a partnership deed, it's governed under deed law. And what that means is that each partner has to sign and their signature has to be witnessed by an independent witness. So that's someone over 18, not related to them, not another partner. I normally suggest asking a practice manager to witness, or the next door neighbour. A partnership is not like a company, so there is no external or central body that governs it like Companies House. You simply keep a hold of your deed and make sure it's kept safe, and take it out every couple of years and make sure it's right.
Thank you.
So on the back of that, Peter, so what would happen if a partnership had an agreement in draft form but hadn't got around to signing it, and it's been sort of 6 months to a year? Would that be that if anything were to happen, they could use that as the basis of their agreement, or would it be that they wouldn't have an agreement in place?
So technically speaking, they're a partnership at will because there is no written and correctly signed deed in place. However, if that went to a dispute, the arguments the lawyers could potentially use is called custom and practice. So that draft that they had, were they abiding by it? Were they doing what it said that they should do? And then they need to provide evidence that they were. So, for example, minutes of meetings, emails, etc. And then it would be up to the courts to decide whether that custom and practice obligation had been achieved. And it's a really difficult one to do. That's why partnership disputes cost hundreds and thousands of pounds, because a partner can turn around and say, well, I didn't agree to that in the deed and I didn't do it. And at that point, you're completely, thinking, well, it was just in draft form. You can't force someone to have abided by it. And where is your evidence in saying that you did? So it's not clear cut at all, which is why I don't leave it in draft form.
Thank you. That's helpful. Any other questions at all? Cool. So we've got one from Kamlesh Kaur in the chat. What is a reasonable lease length?
So reasonable lease length, I would have to refer this to my property colleagues, but I believe anything between 10 to 20 years. I believe that's what is normally agreed with the district valuer and the ICB as to a reasonable length. So obviously I'm talking about short-term leases, a rack rent that doesn't have a capital value.
Thank you. And so a question from David Marks. What additions should be included for non-GP partners?
Yep, so I do quite a lot of partnership deeds with non-GP partners, especially sort of in the last sort of 5 to 10 years. That can range from practice managers and practice nurses. I recently did one who was a partner who was a pharmacist and he'd become a partner. So you need to make sure that, let's take it separately. Let's look at clinical and non-clinical. If the clinical partner is a non-GP, just make sure you've got obligations in there, that they have insurance with their insurance company, that they comply with their regulatory bodies, etc., that they've got all of the things that they need to be in order to make sure that they can practice. If it's a non-clinical partner, the majority of non-clinical partner provisions I put in they don't have decision-making rights for decisions of a pure clinical nature. And in that situation, you would want them to be indemnified for any decisions that are taken by clinical partners that they aren't involved in. Other than that, they would still be bound by the terms of the partnership deed in the same provisions as the clinical partners.
Thank you. So it's been a really helpful session, Peter. Thank you for that. It's really good insight into partnership deeds and premises along with it. We'll share a copy of this recording along with the slides, if that's okay, in our newsletter this week. Brilliant. So thank you very much for that.
You're very welcome. And please do put my contact details with that as well. If anyone wants to contact us separately with regards to a new deed or any other issues, then just please do let me know.
Brilliant. Thank you. Will do.
Thank you.